Justice Indira Banerjee, Dr. Lalit Bhasin, Mr. Parasaran, Mr. Ashok Desai, Mr. Shyam Dewan, Mr. Prashant Kumar, Mr. Manan Mishra. I hope I've covered everyone. It's indeed a privilege and an honor to be asked to speak on this occasion. I'm rather moved, and I think it's a privilege primarily because I have before me some of the legends. I have two of my teachers, Dr. Bakshi and Dr. Mulchand Sharma, and then Mr. Parasaran, who was a Solicitor General when I joined the profession. Mr. Ashok Desai, again another Solicitor General, whom they were all very remote figures when I joined the bar. And besides that, many of my friends, my seniors, I can see Mr. Acharya, I can see Mr. V.R. Reddy. Again, they were doyens from different high courts who, in the case of Mr. Reddy, who actually practiced in Delhi, Mr. Janak Dwarkadas, whom I have not met, but about whom I had heard so much. So it is quite an honor to be asked to speak here on this occasion. Friends, I do not wish to take much time because today's ceremony is to partly commemorate the event of Mahatma Gandhi's 150th anniversary. That is the occasion, but also to celebrate the achievements of fellow lawyers. And to say that I feel proud that I'm calling myself a fellow lawyer because I'm a part of the larger legal community. As an aside, I might say that I have been also a member of the Bar Association of India for the past 25, maybe even 30 years, I don't know. Lawyers are heirs to a noble tradition of intellectual inventiveness. This is what Sridhar Ramphal, the Secretary General of the Commonwealth, said once in an address to South Asian and Southeast Asian lawyers. Professor Veera Mantri, a judge of the International Court of Justice at The Hague, raised disturbing questions about lawyers and their role in society in the wake of technological changes. In his Slumbering Sentinels, he depicts on its cover the bench and bar alike in varying postures of slumber against a backdrop of a computer readout. A passage that has relevance for us all reads, "Science and technology have burgeoned in the post-war years into instruments of power, control, and manipulation, but the legal means of controlling them have not kept pace. Outmoded and outmaneuvered by the headlong progress of technology, legal principles that should control it are unresponsive and irrelevant. Legal structures and concepts and people who work the system are proving unequal to the task of protection in the midst of a set of problems without precedent in the law. Assumptions long regarded as fundamental no longer hold true. Values once held unquestionable no longer command acceptance. Zealous advocacy today denotes a win at all costs mentality that abdicates responsibility for the kind of argument one ought to make in the pursuit of furthering the client's interests. The rules place only the outer limits of frivolousness and delay on the kind of arguments that a lawyer may assert, but even backs off these standards. Richard Wiesenthal, in Lawyers as Professionals, Some Moral Issues, describes lawyers as amoral technicians whose peculiar skills and knowledge in respect to the law are available to those with whom the relationship of client is established. What is characteristic of this role is the lawyer's required indifference to a wide variety of ends and consequences that in other contexts would be of undeniable moral significance. The current century conjures an image to the mind of lawyers as experts on the law. In this character, lawyers assist clients in solving legal problems, oftentimes intricate or difficult problems through the medium of application of law to the peculiar facts of the case. They use legal analytical skills coupled with their experience and familiarity with the legal system and the subject matter. Resolving such legal problems calls for traditional qualities of good lawyers, that is, abilities to detect issues, drafting abilities, analytical abilities, and skills as negotiators and advocates. Now more than ever, lawyers must possess a great degree of highly sophisticated functional and procedural knowledge. Considerable judgment, too, may be involved in this role as technical experts. The law may be vague or unclear. Its real basis could be hidden under a legal tenet, or worse, obscured by imperfect drafting. And we see all of this. As a result, in helping the client take informed decisions regarding action, every good lawyer must exercise judgment in advising the client about the probabilities of different outcomes as regards what is the law and what the relevant facts are. This application of technical expertise, both legal and factual, is at the heart of an increasingly large number of advocates' specialized careers. In addition to being technical experts, they are also often called upon to be wise counselors to their clients. In performing this role, lawyers usually ask about a particular course of action as to whether it is lawful, but further questions are, is it right, and what should be done? There are two different ideas behind the phrase, is it right? In technical legal matters, counseling, the provision of sound judgment to the client about the right course of action is often necessary, either when requested by the client or volunteered by the lawyer. The counseling of the right choice under the existing law and circumstances is itself quite a complex and challenging task. This notion of the wise advisor is the role of the lawyer as facilitator, not just advising on what is correct while making a challenging legal decision, it is also advising on what the right course of implementing that decision is. The second is that the lawyer has a particularly onerous and multidimensional role to fulfill. Justice Matthews said a counsel has a tripartite relationship, one with the public, another with the court, and the third with the client. That is a unique feature. Other professions or callings may include one or two of these relationships, but no other has the triple duty. The satisfaction of the obligations and expectations arising out of these three contacts and interacts are often hard to resolve. The advocate's part in these three capacities necessitates deeper probing. Each lawyer acts on behalf of her or his client and is representative of the client. This is principally relevant in an adversarial structure of dispute resolution prevalent in common law jurisdictions which have a neutral adjudicating authority, that is, the courts, based on the contentions made before it and the evidence placed, decides the questions and the disputes. The advocate or attorney's role in such an adversarial system is to represent the case of the client before the court. The advocate has a grip over the subject matter. The lawyer's skilled function consists largely of providing counsel to his clients about how to mitigate the incidence of the law's obligations, availing of ambiguities and defenses available in the law. Here, a law is basically an advisor. The contractual arrangement with the client obliges him to offer sound legal advice and show the court all that can fairly and reasonably be submitted on behalf of the client. The oft-quoted comment of Lord Reed in the celebrated case Rondell versus Worley pithily bears a sense of an advocate's duty towards his client, which is every counsel has the duty to his client fearlessly to raise every issue, advance every argument, and ask every question, however distasteful, which he thinks will help his client's case. He also said that as an officer of the court concerned in the administration of justice, a lawyer has an overriding duty to the court, to the standards of his profession, and to the public which may often and does lead to a conflict with his client's wishes or with what the client thinks are his personal interests. Another new role which society expects of lawyers increasingly, and I think the Bar Association of India also has spoken about it, and you have held symposiums on this many times, is the adoption of a non-litigious approach and promotion of solutions aimed at swifter resolution of disputes through alternative modes such as mediation, negotiated settlements, and so on. This role has become very critical given the priority which policymakers and international communities are increasingly placing on these modes, which ensure at times swifter and more acceptable outcomes, assuring in many cases that disputes do not fracture long-lasting business and familial relationships. The introduction of the mandatory mediation option, or rather compulsion, before suits can be filed under the Commercial Courts Act is one concrete instance in point. Therefore, lawyers today need to be skilled or at least open to accepting these steps in aid of their clients' best interests. We are today commemorating Mahatma Gandhi's 150th birth anniversary. What he said about the role of lawyers, which is that it is their duty to unite parties riven asunder, assumes great relevance. Last, an extremely important role that the lawyer fulfills in every society, and more so in our country, is to provide legal aid and counsel to those who may not be able to afford it. The importance of legal counsel to every person who needs it, regardless of status or wealth, has been emphasized. Our constitutional vision of equality, liberty, and fraternity in the challenge posed by an unequal order is known to all of you. The role of lawyers who stand for liberty and their obligation to provide free legal aid and pro bono services has been commented upon too. These are invaluable ideals which every lawyer should hold dear in her or his heart. There is one more reason why providing services free or for less than one's normal fee is an obligation. Learning is valued from time immemorial in this land. Learned professionals, which is teachers, lawyers, and doctors, traditionally were seen not only as thought leaders, but guides and cherished for their wisdom. Society not only expected them to guide, but also pass on their learning and share it selflessly. It is in this spirit of sharing which ennobles the profession of the law in the context of an unchanging value system that our country can boast of. This century is often described in terms of being a technological revolution. Our society lives in the midst of tremendous technological changes. Advances in the digital arena have greatly updated and simplified the role of businesses. Significant cost reductions, increased market exposure, and technological opportunities have resulted in revolutionary changes in the way companies and the professional services industry conduct businesses. One finds some of these changes integrated into the role of the legal profession, fundamentally altering it. Paperless environments, digital filing, mobile apps, and comprehensive court websites to disseminate information relating to cases and much more. These are only a few examples of changes that have filled the legal sphere in recent years. The question is, which these changes lead us to confront is whether the future of the legal profession is viable. Clayton Christensen, a Harvard Business School professor, spoke about disruptive innovation, the potential for cheaper, simpler, smaller, and more convenient products to displace the existing market and value network. Disruptive innovation in the digital age is common. Notable modern-day examples include disruption of physical consumer retailing through online shopping. Likewise, the legal sector is not immune to these developments in the digital sphere. Digital disruption has meant that traditional law firms that once dominated this industry must now compete with a whole host of other emerging competitors. One of the biggest challenges for the lawyers today, or if it is not, it is something that you will all see, is being able to adapt quickly enough with the introduction of new technologies. A concern for many traditional lawyers is the brick and mortar structure, which may translate into an inability to adapt with the changing times. Partly increasing technological disruption has signaled the need for continuous upskilling of the modern lawyer wishing to stay relevant in the profession. It has been often speculated whether artificial intelligence and technologies can replace lawyers. There can't be any easy answers. Some of the tasks which are repetitive have been known to be farmed over to artificial intelligence entities. And yet, it is my belief that the way the lawyer thinks, while robots could generate findings and sort through relevant precedent and legislation, they are incapable of many human skills that make up the role of a lawyer, including the ability to make convincing arguments, taking into consideration the specific context involved, individual client circumstance, and human experience. And if I may add, the role of the lawyer as an innovator, in the sense that the one who thinks differently, that can never be captured by artificial intelligence. In this context, there is a frame of mind which I would advocate to all of you. Resistance to or reluctance to change is a significant hindrance to law practitioners in the face of digital transformation. Individuals often resist change when they do not perceive any immediate benefit. Lawyers are not likely to be replaced soon. Today's lawyer, according to me, must interpret legal issues with a new outlook, with an open mind, and considering fresher, untouched opportunities which convergence of the law with technology has thrown up. The modern lawyer must be receptive of new concepts and eager to learn and update skills as newer digital tools and technologies infuse the legal world. At the same time, she must retain and practice the values which are the hallmark of our calling. Digital innovation has disrupted important past barriers in legal practice and afforded lawyers from all over the world to connect. The lawyer today is expected to be open to and possess a degree of cultural competence in their interaction with clients and professionals from diverse contexts. Change, it has been said, is the most powerful law of nature. It is inexorable. As history of humankind has shown, change is the hallmark of civilization. If one remembers this, and that one cannot expect to achieve new goals or move beyond our present circumstances unless one changes, the peril is that the ongoing technological disruption would render irrelevant most things which we dearly cling to. Instead, embracing change and moving away from a hitherto cloistered and cocooned world, even while refashioning the ideals and essential tenets of the legal profession, would do us all a service. I would end this with a quote from the great Judge Learned Hand in an article contributed to the Harvard Law Review in 1916, where he said, "The profession of the law has its fate in its own hands. It may continue to represent a larger, more varied social will by a broader, more comprehensive interpretation. The change must come from within. The profession must satisfy its community by becoming itself satisfied with the community. It must assimilate society before society will assimilate it. It must become organic to remain a living organ. No political mechanism designed to accomplish this by fear will succeed. Succeed in the inward disloyalty of purpose remain. The lawyer must either learn to live more capaciously or content to find himself continually less trusted, more circumscribed, till he becomes hardly more important than a minor administrator, confined to a monotonous round of record and routine without dignity, inspiration, or respect. There can be no ambiguity in the answer of those who are worthy of traditions and the power of a noble calling. Thank you.
Thank you, Justice Bhat, for these words of wisdom. But I can assure you that there can never be, artificial intelligence can never be a substitute for a lawyer. Whenever I visit the law schools, and I do that quite often, I tell the young students that you can do all type of research on Google, on your net and everything. But remember one thing, there can never be a substitute for a law teacher. A law teacher will always be required and needed, and that is the role of a lawyer, which Honorable Justice Bhat has highlighted. May I now request Honorable Justice Banerjee to say a few words to us. Would you like to speak from there? Oh, thank you.
Distinguished persons on and off the dais, ladies and gentlemen, it is a privilege for me to be here today on this occasion. After all, I was a lawyer for about 16 and a half years before I was elevated to the bench of Calcutta High Court. Today, I'm reminded of those junior days in the profession when walking down the corridor, a solicitor would just put a back sheet in your hand and say, address the court. Without any preparation, without any warning, I have been asked to address this august gathering. And I do not have the temerity to talk about professional ethics, profession or law before persons before whom I have learnt the basic tenets of law. I'm just reminded, I feel nostalgic. I'm reminded of those wonderful days of conferences at the chamber of Mr. Anindo Kumar Mitro, one of the persons being felicitated today. And I'm reminded of an interesting incident. I went to Mr. Mitro to ask for time for a conference. He looked at me. As usual, his diary was absolutely full. He had little time for anyone else. So seeing that I was a lady, he told me, Indira, what can I do? If it were a man, I could have given the last time, but I can't ask you to come at 12:30 at night. I told him, give me the time, I'll be there. Ultimately, I got a much more convenient time. Those days were wonderful. I am thankful to him. Also for another reason, Mr. Mitro, whenever he was given a settling brief, he invariably found it more convenient to dictate instead of actually sitting and doing the corrections. This is what he did whenever he was given a settling brief. On one occasion, possibly because he didn't have enough time in his hands, there was a written statement of mine which was given to him for settling. He just put in 1 or 2 words and then returned it as settled. And it got me a lot of briefs from Meharia and company afterwards. Mr. Mitro has not touched the draft. That was the advantage. It was 20 years ago that I attended a symposia organized by the Bar Association of India, That was on the occasion of the 50th year of the Indian Constitution. I was also made to present a paper by default, and that was when I became a life member of the Bar Association of India. So it feels nice to be back here. Now the culprit for whom I'm here today is Mr. N.L. Raja, who is also being felicitated. A few days back, my office was being contacted. I am being felicitated. Chief should be there. They still refer to me as the chief, though I'm no longer a Chief Justice. I think I've been longer here than I had been Chief Justice of Madras High Court. But the tremendous cooperation that I got from the lawyers of Madras High Court, and then of course Mr. Raja, his contribution to the restoration of the heritage building. While I was in Madras, we celebrated completion of 125 years of the High Court Heritage Building. Then his contribution to conducting the walks. Do you still have it every Sunday? Yes. Now I shall participate in the walks. The next time I I visit Chennai. And then of course, his contribution to the book on the Madras High Court are very valuable contributions to the history of Madras High Court, I should say. I take this opportunity to congratulate each and every one of you who is being felicitated. I'm not taking all the names lest I should miss out any, because as I said, I'm totally unprepared today. I thought I would be able to sit at the back somewhere in the audience, see you get felicitated, quietly congratulate you, and run away. And I really wasn't expecting this. I can, before I conclude, because I don't want to take much time, I hardly need mention the importance of the judiciary, the judicial system. Oh my God, I see another one of my seniors with whom I did so much of work, Mr. Sudipto Sarkar sitting there. Wonderful. That really makes one feel nice. I had not noticed earlier. Now, the importance of the judicial system hardly needs emphasis. And we can properly function and discharge our duties when there is absolute cooperation between the bar and the bench. I, for myself, can say that the best judgments come when there is good assistance from the bar. I can also, sorry I forgot, there is another person sitting here with whom I had occasion to do a lot of work when I was in the Calcutta Bar, and that is Mr. Arun Jhunjhunwala, the then partner of Khaitan and Company, who briefed me a lot in my junior days. Now, Mr. Parasaran would possibly not remember, because I was very, very junior then. You know, I basically practiced in the Calcutta High Court, but I used to sometimes come to the Supreme Court, particularly when there were appeals from orders passed by the Calcutta High Court in which I had been appearing. I had attended a conference at your chamber in connection with an appeal from a judgment of the full bench of the High Court in the Calcutta Thika tenancy case. ultimately, the matter was never heard out by the Supreme Court and the law was changed. The Calcutta Thika Tenancy Act was replaced by the West Bengal Thika Tenancy Act. At that time, it was it was a wonderful learning experience. Had occasion to appear with others as well. Those are very happy memories. Now back to what I was saying, is that the best judgments come with the assistance of the lawyers. And the time has come when unitedly we strive to uphold the constitutional values which are so wonderfully summarized in the preamble to the Constitution of India. It should be our joint endeavor to secure liberty of thought, expression, belief, faith and worship, to ensure equality of status and of opportunity, to uphold the secular values which constitute a basic feature of the Constitution of our country. Once again, I congratulate those of you who are being felicitated today, and I thank Bar Association of India for giving me the opportunity to share my thoughts with you. Thank you very much.
Thank you, Justice Banerjee. I must share with you that 1999 we had that famous conference when the eve of 50 years of India's constitution. The conference was on Constitution Revisited, and that is where Honorable Justice Indira Banerjee contributed an article which, we placed it in the special brochure which was brought out on the occasion, and it was in the archives of the Bar Association of India. But suddenly, Justice Banerjee, about 10-12 days ago, I think remembered that article which she had written, because she didn't have a copy of that with her.